stage. This panel is going to be a conversation about patent owner strategies. And not to divulge too much out of the gate before we get going, but whatever you think this conversation is going to be, I can almost certainly assure you it's not going to be that. We're going to talk about a whole lot of robust strategies and situations where patent owners may be willing to do things that you wouldn't suspect patent owners would do because it's to their strategic advantage. So if you have any questions, like any of the rest of the panels, please just raise your hand and we'll get a microphone to you, or you could just shout out the question and I can repeat it for the tape. But let's just get started. Let me introduce the panelists, and we'll start from the audience's left. We have Amanda Bonner, and Amanda is a partner at Mayer Brown and the Chicago office, and she's a member of the firm's intellectual property practice, and she focuses primarily on patent litigation in IPR proceedings. Thanks for being here, Amanda. Thank you. Next to Amanda is my good friend, Michael Golford. Now, I know a lot of you are good friends. Michael and I, we go way back, and longtime friend and a good friend for us. He's always been willing to come to our programs and speak. He is a co-founder and partner of Shorn IP Capital Management, and he has the distinction of previously having been a patent litigation partner at a major firm, and he started this funding, consulting, investment group right during the collapse of the real estate collapse. And so I always tell people that anybody who did that and lived through it and continues in the same business has to be somebody who knows what they're doing. And I always appreciate having Michael here. Thanks for being here, buddy. Next to Michael is Ben Herbert, and Ben is a patent and trade secret attorney. He is a partner at Miller Barendess, and he is also, previous to that, been involved in patent litigation funding. So we'll get a little bit of perspective and cross-talk between him and Michael for that. And Miller Barendess is also a sponsor of this program. Thank you very much for sponsoring us here today. And last but certainly not least is Ben Weed, and Ben is general counsel at Ridge. And Ben is, I think maybe we'll just start with you and jump right into it. Ben has got some interesting strategies for patent owners. Now, they're not necessarily going to work for every patent owner, but if you have a product that you are selling and you have knockoffs that are trying to literally steal sales out from under you, you've got some interesting strategies. Don't want to pigeonhole your initial comments, because we will talk about that for sure. But where do you want to begin the conversation with your preliminary thoughts?
So what Gene is referring to is that we don't really care much about past damages at all. So we look at a strategy where it's all about injunctive relief, it's about ITC relief, it's about using Amazon and other platforms to help us enforce our IP without much regard for past damages. Most of our defendant-type targets don't have a lot of money, and if they do, it's not in this country. So it's really all about how do we keep the infringing units out from the borders of this country, because that's primarily where we do our business. The other thing that does for us, which is nice, is that new continuations when they issue are hugely valuable, because we don't care if there aren't any past damages. It issues, people are infringing it right away, and any patent that's being infringed is also one we're practicing. So we have kind of a nice situation where we can prosecute claims as narrow as we want. They're going to be infringed, we're going to practice them, and it just makes it harder and harder for people to invalidate the claims in any form. So we heard yesterday a little bit about if you have $1 billion, damages number coming at you, an IPR on 50 patents is a drop in the bucket. For us, it's the exact opposite. Most of these people we assert our rights against really can't afford even one IPR. So if we can stack a couple of patents on top of each other, it's almost kind of a death knell. And we've had people get out of the industry by agreement because they just don't want to deal with the enforcement that we can do.
Yeah. And you have also said in the last panel, let's just bring it up and throw it out there and we can talk. I suspect there'll be a lot of questions. Please feel free to make this interactive. That you also, if you do get IPR, you'll amend the claims. You don't really care. I mean, because what you want is the patent's going to come out of IPR with amended claims, and that's not damage to you.
Yeah, we can't have claims that are too narrow. So any claim that exists is good for us. We don't care about what the value of the claim is. If it's infringed, it's valuable to us. And so we are open to all strategies, whether it's, again, filing new continuations, new applications, amending claims in IPRs. Design patents are very valuable to us. So we have a family of patents that can support designs and also utility patent claims. So we use that to kind of deal with what people are trying to do in the market to design around some of our existing IP. And so it's kind of a multi-pronged approach where anytime anything new issues, whether it's an amended claim in an IPR or a new patent continuation, it's very valuable to us.
Okay, great. And the last thing, just very quickly, if you're not familiar with Ridge, what is it that you guys actually do?
So we make, where did I put it? We make a compact wallet. It looks like this, which is shocking that there's IP on this, but there is. And we sell about $150 million of those a year. So it's a real deal, and there's a lot of revenue there, and the margins are astronomical. They recently hired me and Gina from K&L Gates to come in-house because they had enough litigation where it saved the company money, and that's also luxurious because we can file new cases with just local counsel or at the ITC without having to engage an outside law firm to do a bunch of work and spend all that money. It's kind of by being in-house, we can be hired guns without the cost usually associated with a new filing.
Great. And panel, just avert your eyes from the minute. I'm going to turn on the lights, give you a little bit more light, and that way you won't look quite as pasty on the recording. Sorry about that.
I don't know if that's possible.
What are you saying?
I'm sorry.
What are you saying?
I was looking right at you when I said it. I didn't mean to.
You
it's
picked
like-
on the tannest person.
Yeah,
What are you saying?
I picked up- right. That's the problem, being friends. Sometimes I think we're up here and we're really just out at the Warwick having a drink, like good old times. But let me go on the other end of the panel and get Amanda's initial preliminary thoughts, because I think they're going to be a little bit different than Ben's experience.
Yeah, to come from a different perspective, what I do generally is a lot more behind the scenes for patent owners. All the steps, all the work that goes on before a case is ever filed just to ensure a more successful long-term outcome. We're thinking much farther down the road at the same time as when we're thinking about what the first step will be for a particular client and how to protect their patent portfolio.
Okay, and what types of clients do you represent? You're high tech?
It's usually high-tech consumer electronics.
Okay, all right, great. Michael, we'll go to you next.
Selfless plug here. I think as the finance guy, I guess, in the conference, I don't know if there's too many other finance people, I guess, sitting here the last 2 days. So I guess, have the unique experience of getting to see a lot of matters from the largest of large companies that are engaged in patent disputes to even, frankly, we've been talking to like a number of companies that just got blatantly ripped off on Amazon, right? They make a product that maybe makes $1 million or $2 million a year. They play the whack-a-mole game of every time they get one little guy to shut down, it's like whack-a-mole and another entity pops up. So we see the whole gamut. And it's an interesting panel to talk about strategies sort of for enforcing patents. And I guess my maybe overly biased viewpoint on this is that it's very difficult to separate the word strategy without the word finance or financial considerations. And I think what I mean by that is from where we sit, even I think the luxury of being able to say, like, we don't care about money, right? We just want injunctions. And I know a ton of small consumer product companies that say the exact same thing. That's literally all they want, right? But if you have some venture capital and maybe you're making $1 million or $2 million a year, when you've got to go to the ITC, the numbers just don't work, right? It's like, well, it's going to cost $6 million to stop $1 million in infringement, and it keeps coming, right? So for those kinds of companies, it's sort of heartbreaking, right? Because that strategy is just it's not viable, right? So I think a part of this is it's hard to separate all of this talk from like what's the staying power financially of the business that's involved. So that's on one end, and then on the other end, when we talk about strategies, what's interesting is I guess I don't share the view that the defendant population has like a moral duty to take a license to an IP. I wish that were the case. I think corporations have a duty to their shareholders to maximize profits, frankly. And I know that corporations view that the same way. And so I think despite when you come, I've noticed some sort of doom and gloom about, you just talk about how bad things are and it's impossible to get deals done. I don't think that's the case. I think from where we sit, we see deals happening frequently. But one needs to know that it's not going to happen without a fair amount of battle, right? You're going to have to prove that your IP is valid and it's infringed. That might be through IPRs. Well, it's definitely going to be through IPRs, but it could be through re-exams. It could be through multiple rounds of litigation. But my point is that's the reality of the world we live in. So again, even on that front, I think, at least from what we see, and what might be surprising is even for the largest of large companies engaged in that, that conversation and that business strategy, financing for them is super, super important too. So I know I'm sort of selflessly plugging the idea that patent owners and law firms should probably think about having a financial partner, whoever that is. I mean, but I think it's an important consideration.
It is, and so the strategy Ben uses is not going to be right for everybody, but I think it's interesting to think about, and it will hopefully throughout the rest of this panel we'll talk about. Okay, so when are you in which bucket? Because sometimes, particularly people that are new to this, first-time inventors, startups, maybe even experienced inventors, like they invented at a university before, now they're starting their own. They don't necessarily understand which bucket they belong in. But thanks, Michael, for those initial thoughts. And Ben, you'll get the final word on the first round here. What do you think people need to focus on as we roll up our sleeves here and talk about this particular issue?
Yeah, so I think the common thread between what Amanda said and what Ben said is fundamentally you have to go into any as an outside counsel when you're meeting with a client for the first time, or if you're in-house counsel trying to find out with your strategy, the first question has to be, well, what's a win look like for you? And I don't want to use the term, how are you going to monetize the IP asset, because I think that leads people to think, oh, it has to be about money. So I think it's probably better to think about it, well, how are you going to get return on investment on that IP? And yeah, your strategy is dramatically different than your client's strategy, but fundamentally the common thread between all of them is, well, we have an understanding of what the return on investment, what a win looks like for our client, and that has to be the jumping off point to whatever strategy you're going to go forward with. So I think you guys are all starting in the same place. It's just you're taking a different path, because for you, all you want is to have the knockoffs off the market, and so that you can be selling your product, and you don't care about damages. Your client, they want the damages. So to me, I don't think you're fundamentally saying a different thing. I think we're all launching from the same point. It's just the strategy dramatically varies based on what outcome you want to get, and I try it, and coming from doing litigation funding for a little while, I sort of come at it as, how can I get the return, whatever that looks like, for the client as quickly as possible? And that's sort of how I go into these questions and try and figure out, well, how can I do it cheaply and quickly, accomplish the goal that the client wants? What's their win?
Mm-hmm. Yeah. And so I think the takeaway, and what I'm hearing you say, and maybe all of you may agree or disagree, but maybe it's worth going around the horn to see if you agree or disagree, is the patent is an asset. So for the patent owner, you have to look at the patent as a tool. Any other business asset that you have, how do you, based on your business in the marketplace, and the money you have, and maybe the money you're making, all those things together, how do you maximize the value of that asset? And that can be different for different players. Would you all agree with that?
Yeah, I think one thing that's important, it's a great point, but I think it's also important to think with your clients about who the defendant is matters to what a win is too. So most of our defendants are little guys where they're going to pop back up, but if we can take them off Amazon for a week or a month, that's a win. There are other defendants we have where they're more established, they're a domestic presence here in this country, and so our strategy is a little different. We have a damages model. We're going to go after them for as much as we can, not because we want the money, but because that's where it'll hurt them. If we can make their margins go away by a damages judgment, then they'll be off the market. So a win is the important thing for sure, but I think who the defendant is matters drastically on who the win is, or what the win looks like.
I'd say that matters for us too, and it's not just who the particular defendant is, it's who are all the defendants that are infringing or appear to be infringing the patents. And knowing that from the beginning, doing that research, seeing what the market looks like, and in a sense, working backwards, ranking the targets based on potential damages, the market size, what their products look like, the forecast is in addition to the past damages, the size of the target in comparison to the other targets, how many patents they appear to be infringing in the portfolio. There's so much research that's done, not just on a particular defendant, but the entire market.
How hard they'll fight.
And how hard they will fight.
That's important.
And so let me ask you, because I know, Ben, is Amazon your primary market?
Yeah, it's ours, but a lot of our competitors sell their products to the people who ultimately sell on Amazon via Alibaba. So we have to deal
Okay.
with both.
Okay. So are your clients, and not to say this in a pejorative way, but do they tend to be NPEs? Do they tend to sell their own products? Are they kind of a mix? And what platforms might they be using? Give us a little sense.
They have large patent portfolios that are either practiced to a certain degree, or they're generally R&D type companies, innovators, and they find their patents being infringed in a variety of platforms like Amazon, Walmart, Target, Best Buy,
Right.
being sold in companies like that.
Right. So, Michael, that's the different use case, right? You know, if you're an R&D company, the strategy of not worrying about past damages doesn't work for you, because you're not trying to capture the market for yourself in the same way that Ridge is trying to capture the market for themselves. I developed this, I invented this, you are using this.
Yeah.
My product is the research and development.
Well, I think a lot of companies actually want to capture the market. They just realize that's not the system we have in America, right? I think, and we talked about this yesterday. I like the way we explain it to investors is sort of that, you know, generally in the United States, it's legal to infringe a patent as long as you pay for it, right? That's really the system. I mean, right? So I think a lot of companies start off thinking that they can own the market, that they can get an injunction. It's like the day of reckoning, right? And you mentioned, and then they realize that's just not going to happen.
Right.
It's going to be, the way it's probably going to end up is some court one day will say, well, you're right, it's infringed, but there's a way to deal with this, and it's through money. It's not through you
Right.
owning the market, right? Don't even get me started.
Well, no, but it might be worthwhile to resurrect that. I mean, what you're talking about is, so I said something that probably a lot of people thought was controversial, and when I said it, you know, and I've danced around saying it before. I said it way more direct yesterday than I normally do, and I've thought about it, and I actually kind of qualified it almost immediately, because, you know, it's not without its problems, right? Recognizing exactly what you said, whether we like it or not, we live in a country where it's largely a compulsory licensing system, right?
Oh,
That's
yeah.
just
It
that's
absolutely
descriptive.
is. No, but absolutely.
So I said that I can understand, you know, based on the four-factor test, what we have, and the view that money solves all problems, which we can quibble with that. You know, I would quibble. I don't think money solves all the problems for a variety of complex reasons, not the least of which is you're ignoring the patent owner's ability to control the market for a period of time and then develop their own brand name and develop dominance on their own. But that doesn't seem to matter at all. So if you throw that out of the equation, based on the equities test, I don't see it being out of the realm of, or outside the envelope or off the table to say NPEs should not get injunctions, okay? That, however, also I think requires, which we also don't do now, is that you're dealing with rational people who are working with you in good faith. And the other side doesn't have that obligation, and I don't understand why they don't, but they don't. So there's a lot of things that we could fix. And listening to what you were just saying there, is I forget who it was, and I don't want to steal this, but we were talking yesterday, and they're like, I think it was Mateo, and we were talking about Frand, and it's like, well, you can't expect that you're going to get the Frand rate that's after fighting for 10 years and costing us, you know, $50 to $100 million in legal fees to chase you all over the world, and you're going to get the same Frand rate as the person who signed the contract when in the first quarter we presented it to them. No, that's not fair. That's not non-discriminatory. Non-discriminatory ought to be you're lumped with a group of people that are similarly situated, and you said hell no. So out of the group of people who said hell no, their rate is this. You know, the people who said yes right away, their rate was less than this. And that's not the system we live in. I mean, so there's a lot there. And I'll go to Ben to ask you to initially, Ben Herbert, and then we'll get to inside corporate. Look, so we have two Bens. What's the odds?
And you're looking at us both.
Right, and you're both sitting side by side. So Ben Herbert, What's your reaction to anything I just said, or take us in a new direction altogether if you want?
So my guess is that everyone in this room, when they went to law school, learned about efficient breach of contract in their contract class. And I think we're in a place now where there's a new thing, and it's called efficient infringement. And I think because what's happened in eBay, what has happened in patent damages, and the advent of IPRs and things like that that have generally weakened the strength of patents, I think now companies look at the playing field and just decide we're going to infringe. And it's cheaper for us to infringe and fight it for 10 years than it is to just go around paying royalties for the people that we know we're dealing with. And so I think you're exactly right when you say it requires, the system that people are talking about, I think, does require that you have actors on both sides in good faith. And I don't think, when you're dealing with a situation where you have someone who's engaged in efficient infringement and is sort of knowingly engaging in efficient infringement, I don't think that that's good faith on your side. And I think it produces a lot of problems. And when I was working as a litigation funder for a hot minute, you would always have people come in that wanted to do these big cases, and they want to do some $30 million campaign to try and get $700 million in damages, and you'd say, okay, well, what's step one? And step one is, well, let's go sue Apple. And it's like, well, that's not step one. Of any process that's going to get you $700 million, that is not step one of that process. And it's because they're going to fight do you want to go take a frolicking detour in the desert for 10 years before going up to the Supreme Court maybe twice, getting cert petitions up to the Supreme Court twice and going back and forth? No. So
that's a recipe for lawyers making a lot of money.
Yeah.
Is suing Apple first.
And so I think that people you need to come into it and say, well, what's the reality that we're living in today? And the reality that we're living in today is you go after big companies and they're going to fight you tooth and nail. And what you need to do, if what you want is the money, you need to figure out some way to get there smartly by going after people that aren't going to fight as hard, so you can try and establish what a reasonable rate is, and then use that to go to companies like Apple and say, well, listen, we've got these 5 competitors of you that have settled for this amount. This is a reasonable rate, and try and leverage it that way.
And that's why you do that market research first and
Yeah.
categorize your
Yeah.
defendants so you can plan that out and set the cases in order that makes sense for setting the best royalty rate and then ultimately getting the amount you deserve from Apple.
But isn't the injunction part of it? Right? Because
Well, it's a huge part of
yeah,
it.
but without getting into the policy debate, it's like, well, this is the reality of the way the world works, right? So the reality of the way the world works is, whether it's good faith or not, you've got smart people who are defendants as well.
Yeah.
And they know the system, and so they look at the system and say, well, if we just don't do anything, only 3 out of 10 will even be able to file a litigation in the first place. So we just got rid of 7, right? And then of the 3, we have a system that basically says, you'll pay X, right? Date of the hypothetical negotiation. You'll pay X, but probably not more than X. So you can delay paying that for 5 years. So why wouldn't you do that? It's just basic financial sense, right? So the injunction is the actual, whether you want to argue that it makes policy sense or not, it's the thing that changes that whole easy to figure out and diligent system to say, oh, there's a whole other animal here. So maybe we should have an actual business dialogue. It's, in my experience, it's one of the only things that forces an actual business dialogue, because big companies are very good at diligencing and getting comfortable with district court risk. It's very easy. You have analytics. You know how long it's going to take. You know what the other side is. You know exactly how far you can push out a payment.
You know who your judge is.
Yeah. I mean, so the injunction, just that the threat of it being there, it's really the only thing in my experience that just totally changes the whole.
So I
conversation.
agree with that. I mean, eBay changed the dynamic to the point where, and I fundamentally think, and I've written about this a couple times, about the Coase theorem and how it applies to law and that sort of thing. I think any law that pushes people towards litigation as the first best, most reasonable alternative is bad. It's stupid. There's a reason that 97, 98% of all disputes settle, right? Because the law is set up to try and get people to resolve their disputes. The courts are there to help facilitate, and then if you force us as the courts, we'll make a decision. but we really want to be here as a process to help you guys get to a resolution that everyone can live with. And in our space, that's not possible. And if we're not going to have an injunction, fine, I'm fine. Literally could be fine with that. But I do think we have to revisit this damages question, because you can't go a decade saying hell no, hell no, hell no, hell no, and that not wind up at the end costing a lot more than somebody who paid willingly at the front end. I mean, nobody in their right mind would do business that way. Am I crazy? I mean, we need one or the other. We need, as Jen
You're
said
exactly
yesterday,
right, yeah.
crippling damages. We don't have crippling damages. We have a federal circuit right now that, I wonder, do they really understand the math? I mean, the math is simple, right? It's how many products, what's the rate? Oh, that number's way too big. I must have done the math wrong. No. What you're doing is you're observing that there's massive infringement. So the fact that you're not okay with $1 billion verdict in 2024 federal circuit, that is the problem.
Amanda, I'm curious, because I know that you're in the ITC and you're in district court. What do you think is what gets things done, right? Is it the large potential damages award, or is it the injunction wrapped up with that?
It's the ITC case. In any litigation strategy we're putting together, the goal is usually to ultimately have an ITC case, because that is usually what gets the defendant talking.
So, and I get that, but so I don't want to seem Pollyannish about this,
No,
right?
but you're totally right on the damages.
We don't have.
There's no disincentive.
There's none.
It's the rational behavior given the system. we're in.
Absolutely.
Yeah, 100%.
And on the Apple side,
Right.
like Ben just said, jokingly, sort of, right? We go up to the Supreme Court twice, right? And the reason why is because every appeal layer reduces that amount of damages. I mean, the big news story in our generation as patent professionals is how worthless Apple's portfolio was, right? I mean, Samsung made almost $100 billion over the relevant period of the infringement, ripping Apple off. Everybody knows they were ripped off. They copied them. And the only thing Apple had was a design patent. They went after them with a picture. And they won not enough money to justify what was taken from them. And then every step of the way on appeal, the number got reduced, until now it was so low Samsung could pay it and say, oh, okay, well, it's not worth paying the lawyers anymore. We'll just pay this, Am I wrong, Ben?
No, you're not, and I think to back up Amanda and I think what Michael was saying, of course it's the injunction is the important thing, and that's why you now are seeing companies trying to get eBay to be the standard that's used at the ITC to adjudicate whether or not you get an exclusion order. Like, of course it's the exclusion order.
So I just want to fight on offense, right? I mean, it's like, if that's important to you, that's fine. Then let's revisit. It's not triple damages; it's 10x damages in the statute, and it's not, and it's loser pay. I mean, if you had loser pay, attorney's fees, I mean, and you stack these things up that are saying, because you're dealing with people who are saying no at all costs, and patent owners, I think, need to get proactive about this.
I think it's important, though. I mean, we're talking about royalty rates as the driver of damages. There are other damages out there, right? I mean, if you're practicing the patent, you can more likely get an injunction. You can make a domestic industry argument at the ITC. You can get lost profits. I mean, I think fundamentally it's also about the nature of the patent owner. So if you are a patent owner that happens to be practicing and competing with Apple like Samsung was, it's a different ballgame entirely. So I think part of it is, and we talked before about what's a win. Part of it is what's a win based on who the defendant is. Part of it is what's a win based on who you are as a patent owner. Maybe a royalty is a win for a patent owner that just is not otherwise making money with the asset.
Yeah, and we're going to talk about
Can
the
we talk about
ITC.
loser pays for a second?
Yeah,
Because
go ahead.
I just think it's a terrible idea. Just because it's so sad, like the system that we're in, right? Because there's so many really great companies that you can't help because it actually
No,
doesn't
and
make financial
and I get
sense to
that.
invest.
I'm just trying to find a
But
solution.
loser pays basically just destroys, I think, innovation from smaller companies because it's just another huge risk that they're not going to be able to take to even take that first step of moving forward. I think it sounds appealing, but when you really think about the swath of innovation that it's trying to kill off, it scares me.
I mean, it scares me too in a lot of ways. I mean, so you, and maybe I'm falling prey to what I always criticize, it's like, I see a problem and I don't want to take out, like tweezers to like pick the fly off the screen. And I take out my shotgun, and I blow the whole screen off, right? Because I see at the very top, a lot of really bad actors who ought to have to pay, and they don't ever have to pay. Well, they have to pay their attorneys, but they don't ever have to seem to pay anybody else. But I guess we do need to also make sure that we're not throwing the baby out with the bathwater, is sort of what you're saying.
Yeah, I think you could probably fix these things, like you said, through policy shifts or legislative shifts or judicial shifts. If you're a company facing a $1 billion judgment, and statistically, empirically, there's basically 0% chance the federal circuit in any day and age would affirm that, regardless of the merits of the IP, you're going to act a certain way. If you think that there actually really is a good chance the federal circuit will affirm that, you're going to act in an entirely different way.
Right.
Right? Yeah, I think you can skin the cat different at a larger, more macro level.
So, and this is the problem as a patent owner. So this is why I want to have this conversation, because I always am trying to think, when you don't want to be a deer during hunting season, right? Because what do deers during hunting season get? They get shot. So I see patent owners as deers during hunting season. They're not firing back, and it's not that they don't want to fire back. It's the law has been so eroded and changed, no injunctions, remitted on damages constantly, no penalty for being unwilling, et cetera, et cetera, et cetera. And the fact that even if you're not in a remitted situation, if it's over a couple $100 million, the Federal Circuit is going to say no and find a reason why they have to overturn it. And all of those things. So what's the solution? How do we think outside the box to create a solution? Because I struggle with this, right? Because I don't think we're going to overturn eBay with a law. I mean,
well, I mean, not judge. It's not going to get overturned by judges. I think
Right.
it ends up you're going to have to go to Congress.
and I don't think they're going to do that. I mean,
I don't disagree. I mean, the one thing that I think might help is that everyone now is so enamored, and listen, I think rightly, with AI and what it's going to be doing for the economy. And I think the reality is, if you look at Section 101 and Alice and how that applies to a lot of AI, not necessarily the inventions that come out of it, but the actual core AI and the algorithms and that sort of stuff, it seems to me that you're going to have a really hard time with Alice getting any of that stuff patented. And I think that might be a driving force to getting something on the Hill done, because there's a lot of companies that are heavily invested now in AI, and they're going to bring their lobbyists. And I think that they might be a critical mass that's sufficient to overcome sort of, the chambers crowd and the big tech that are fighting against it. And I think that might be the only hope. But I mean, look how long it took to get the AA.
right. So, and I guess where I'm struggling is I see all the rules in this game that we're playing, and it's like none of them are in favor of the patent owner anymore, and it's like, well, how do you cobble together based on the reality of where we're at now? As you were talking about, Michael, we can wish it's different, but it's not. So what strategies, so Ben has laid out one strategy for a particular set of company that are making products, selling it, particularly on Amazon, and they have competitors in Amazon. So maybe before we go any further, Ben, tell us a little bit about the Amazon program, because there's an Amazon court as well. And do you use that at all?
Yeah, we do. It's kind of a black box, and that's the frustrating thing. But Amazon, in their terms of service with their sellers, will say to people, we have the right essentially to take down your product if we deem it to be in violation of IP. And what that means is very much up in the air. But they are essentially, there is an avenue at Amazon to take your IP to them and say, hey, look, these guys are infringing it. Can you help me? And they will do a number of things. They can take it down for a period of time. They can ask for a response from the infringer. They can do a lot of different stuff. And they will look at what ongoing litigation you have. And one thing that we have seen them be afraid of is getting into a situation where they are acting instead of a court. They don't want to do that. So they're in a tricky spot where they want their sellers to be able to have an avenue to, to remedy for infringement, but they don't want to get in the way and do something a court would otherwise do or not do. They don't want to usurp the role of a court. So it's kind of a wild west right now. They're also developing the program in real time. So it's something where you have to just try, and sometimes it works and sometimes it doesn't. But that is effectively, when it works, it's an injunction. I mean, it is an injunction for a little bit of time perhaps, but that matters a lot on Amazon, where the algorithms drive people to the available products.
And particularly given the, holiday season drives sales for a lot of companies. So
I'm sure they see an
timing matters.
uptick in activity. We certainly have an uptick in activity of just before Christmas.
So I'm excited to hear this, not because this is a strategy that's going to work for a whole lot of people, but it is a strategy that works for some people. And it also, I think, explains, because so some of you might know the name Stephen Key. He's an inventor coach, and he deals, and the people he coaches, they're all getting licensing deals, and but they're selling products, tangible things, like as seen on TV, or they're getting into Target or Walmart or Home Depot or Lowe's or whatever. That part of, if you have those types of things and you want to go use the patent system, I think the patent system works really, really well. And, he always asks me questions like, why is everybody all upset about the PTAB? Because his people don't have the same problems, because they have different concerns. Their concern is sales on Amazon, much like yours, and China bringing stuff in, and stuff that, even if it's not knockoffs and it's clearly an inferior product, is that people going to think it was us and it's going to cause damage? I mean, there's lots of those other things. But the patent system works for those folks. The patent system doesn't work for your folks, I don't think. Would you agree with that?
I think that's fair.
So what do you tell your clients what they need to do to try and level the playing field?
It starts with looking through the IP that they have and the volume of it, and assessing where the infringement is, what the level of infringement is, and from the very start, getting notice letters out to all the companies to, one, make them aware of the infringement, make them aware of the patent portfolio, start the clock for damages if that's the route we're taking, engage in some negotiations to see if an agreement can be reached, which does not typically happen, but at least there's that good faith effort to engage in those negotiations and get that process started with a couple companies at the same time, and from there assess which ones you have to take to the patent system, which you can continue to engage in negotiations with, which you need to send notice letters to. So it's kind of a multi-pronged approach depending on the company you're dealing with, and part of that is learning the tendencies of each of the different companies and how they're going to respond to something as simple as a notice letter, but how they might react and respond if a case is filed. And oftentimes that is necessary to to bring the negotiations to a place where an agreement can actually be reached.
Well, and when you say necessary, that's a purposeful word you're using, right? Because a lot of these companies won't even talk to you unless you've sued them.
Oftentimes the letter is not responded to
Right.
and acknowledged until a suit happens.
Right, it's just thrown away.
Right.
Because of what you said, because they know that 6 or 7 out of 10 won't even sue. So why care until I get sued?
Well, right, and I mean they're set up that way, right? Because when you're friends, you've been in the business long enough. Your friends are on the other side as well, and so you get to have the conversation. They were like, "Hey, man, I can't do anything until you sue us. So can you just like file a lawsuit so we can actually have a conversation?
Or leave me alone."
Yeah, it's just the way the way the game works. I mean, it's just
Right, and then I mentioned to Michael, some of them it requires then not just the district court case, the ITC case to actually get it moving. So it's multiple layers that it takes with some of these companies to get them to take the IP seriously and accept a license.
Yeah. Ben.
And I think trying to get a financial planner like a litigation funder, or there are some patent portfolio monetization insurance policies, trying to get something like that in place so that you're not going it alone and you have the financial backing to be able to withstand the juggernaut. And I think that does help move things with big companies, knowing the mere fact that the typical playbook of grinding this out in the hopes that it's going to make the company submit because they can't afford it. That playbook's not going to work with us.
Yeah.
And I think that I think it's worth investigating those options so that you can come to the battlefield with more of a financial balance between the two different sides.
So let me ask you to explain to the audience the insurance litigation judgment insurance, and I'll just say I think it's a great deal for the patent owner if you can win and win somewhere and then insure it. Take your chips off the table. Now you might get, what is it, 70 cents on the dollar? Is it, or 60 cents? What are you getting?
So there's two different products. The one is judgment preservation insurance, which I think is sort of a hot topic now because, at least in the litigation funding world, I think it's a pretty well-known secret that there are a number of very large patent and trade secret verdicts that have been insured that are now in significant question after appeals, and that's caused the market to change. I think I think if you're talking 4 or 5 years ago, you could probably get close to 100% of your verdict insured if you were and now it's less than that, and the money is way more expensive. Like, it's probably 50 to 70% or something like that now is the cap, and it's a lot more expensive. But it basically says, hey, we're going to guarantee, no matter what happens, that you're going to walk away with, let's say, 50% of your verdict if you pay this insurance policy premium.
And so let's kind of put some numbers out there just to get an idea, not holding you to this as a quote or anything, but like if you have a $100 million verdict, is not out of the question in what we do, and there's some reason to suspect that maybe the Federal Circuit will allow a $100 million verdict to stand, or they won't do too much mischief to a number like that. What do you people have to be expecting to pay for something like that?
Well, I think the premium is usually, what is it, like 20 or 25% of the total?
It's
like
actually, yeah, so the way it works, is this insurance policy, it'll actually be bound by usually a primary carrier and then some follow-on, so it's called a tower. And they each come in with different pricing because the primary has more risk. He pays the first dollars that are lost, whereas the last guy pays the last, so he's cheaper. So when you blend it all together, the price of these policies, these days the market's changing, it's going up. We were kind of in the 10 to 12% world for a while, and now we're kind of in the 12 to 17-ish% world. What's changing is the availability of the policies, right? Because the market is not stupid. So, you had some big judgment preservation policies that were out there. I think the results, some have not gone well.
Some are still should never have been.
Some are still outstanding, and so the way the market's changing, at least according to the carriers, is I think they're really favoring portfolio type risk. I don't know if you're going to see a lot of single patent big awards insured going forward. It's a tough market for that right now. More companies that have big portfolios that have a judgment where people can feel like there's going to be a deal. That's one thing, and then the other insurance product, like Ben mentioned, that's happening. I think in parallel with wanting portfolio type things to insure, is now for companies that are monetizing their portfolio, you don't have to wait till the judgment, right? There are insurance products on day one that basically say, okay, you're gonna monetize or license your IP. We'll do a lot of diligence, and the policy will basically say that if X dollars isn't achieved in X years, say it's 5 or 6 years, then the policy pays. So it's kind of pre-judgment, but
And I'll just say the interesting thing about those portfolio monetization policies is in a lot of instances you can get a litigation funder to step in on day one and pay the premium and a portion of the guaranteed monies up front so that you can actually get the ball rolling with the monetization campaign without having to spend any of your money to do that, or to actually acquire the portfolio, the insurance policy. So like the policy will say, for example, we think in 5 years you'll be able to earn $25 million off of this portfolio. So we will guarantee at the end of 5 years, if you haven't earned $25 million, we will pay you the delta.
Okay.
So I mean, it's an interesting policy because it can get you essentially funding in a situation where maybe on a single case you couldn't get litigation funding. You can potentially get one of these policies
Based on the portfolio.
they're just getting a lot harder to get.
portfolios.
The
They're getting
market's
harder.
changed
So,
a
and that's
lot.
the thing. Okay,
Yeah.
so because would you all agree that when this first started happening, there was a little bit of irrational exuberance in that marketplace?
From the insurance companies?
Yeah.
Yeah.
Yeah. And so would you call it now what's going on, more rational-based, market-based, reality-based.
Yeah.
Yeah.
It's evolved quite a bit.
So it's not impossible, but you got to have a good case, good portfolio, willing to pay more than what you were.
You know what it is on the insurance side? It's like a lot like what Amanda was saying, right? So what they would probably say is, well, when we're looking at things, we're looking for big portfolios, a lot of patents, more diversity, less binary situations where if one thing goes wrong, you lose the whole, the whole thing.
Right.
Yeah, I mean, they want diversified, non-correlated risk.
Right. So, and Ben, can you tell me how big is your patent portfolio? Just to get an idea.
Not huge, 5 or 6 or 7, but there's a bunch of stuff pending.
Uh-huh.
And, we'll see where it goes, but I would say in the next year, it will double or triple in size.
So, and it relates specifically to what you're selling.
Everything that we have products for has a patent pending on it, but the ones that we have issued are on the wallet, yeah.
Okay. All right. So,
Do you constantly have, I guess every family's open, so each year you're growing that portfolio?
Yeah, exactly. And the families get broader and broader as time goes by. It started from one, and when that issued, we kind of blew it out at that time. And that corresponded with the company growing. It's grown very quickly, very recently.
You mentioned design patents too. What percentage would be utility versus design?
Of the pending stuff, it's probably 50-50. Of the issued stuff, also probably 50-50. And again, the strategy is to have one parent application that will support designs, utility applications, and basically everything.
So, and let me also ask you, is it correct to say that you are in a marketplace where there's a lot of small infringers? You said you're dealing with a lot, but is it mostly small infringers? Are there any large company infringers?
So yeah, not in this country though. So what our biggest problem is overseas. We have 4 or 5 factories who are making all this stuff. I mean, all of the knockoffs come from the same 4 or 5 places in China, and so they are large actors, which would be infringers if they were doing anything that constituted domestic infringement, but they aren't. And so that's why the ITC remedy is such a big deal for us, is if the ITC issues a remedy that we can use, it doesn't matter where they came from, they'll just stop at the borders. And also, that remedy will cause Amazon to say, okay, I've got a GEO from the ITC, I'm going to act on that. I don't care if there's litigation ongoing, I've got an enforceable order that Customs is also enforcing. I'm going to help you, Ridge, at the borders. I'm going to help you with Customs figure out what's coming in through our facilities and help stop that stuff too.
Are 100% of your infringers on Amazon?
I would not say 100%, but it's pretty high. We have quite a lot. Most of them are on Amazon. There are some that have their own Shopify sites. I mean, you can set up a Shopify site for $5,000, so it's a very low barrier to entry. So we're constantly out there, working with Shopify. They're actually really, really good at actioning these things too. So it's very much I'm in touch with the lawyers at Shopify and Amazon and Alibaba all the time, just kind of keeping them abreast of what's going on in the courts so that when it happens, they'll be ready to act.
So you treat this and have all the same problems of what a lot of companies deal with from a trademark perspective, counterfeiting.
It's essentially a trademark. The patent
Yeah.
portfolio is essentially a trademark, a very powerful trademark that you can use to get damages on a patent basis. You can use it at the ITC, but essentially it's a trademark. The one problem is with a trademark, it's way easier for a paralegal at Amazon to say, yep, that's the same mark.
Right.
With a patent portfolio, someone has to get in there and either look at the drawings or look at the claims and say, yeah, this is an infringement.
Yeah.
So it is harder than a trademark in some ways. It's better in some ways because we can sort of approach the design from different angles.
Yeah.
But it essentially becomes like a trademark.
And that's why design patents are so important for you,
Yeah.
because it's easier than reading the claim. It's looking at a picture.
Yeah, and again, it looks like a counterfeit. It's essentially a knockoff. But we don't have people using our brand too much on the product
Right.
on their
This
products.
is the counterfeit
Yeah.
problem. So I guess what I was fishing there for is to try and figure out, try and give some advice to people, right? And I guess it's maybe as simple as if you have a whack-a-mole counterfeiter problem, then maybe this Ridge patent strategy is something you ought to be thinking about. And if you're a research and development company, then that certainly won't work. You got to come up with something else. I'm trying
it
to
also won't work if you don't have the bank account that Ridge has to go to
Right.
the ITC and do
Well,
what you have to
that's
do.
right.
And you need
That's
to
right.
have the domestic industry that Ridge has for the ITC and.
Right. So it's interesting because companies like Yeti have gotten GEOs at the ITC. Again, they can afford to do that. PopSocket, the PopSocket company, has gotten a GEO at the ITC. So it's available, and the ITC will look at smaller domestic industry cases and say, yeah, there is still a domestic investment. Part of the problem, though, is all of these companies are really, most of the R&D happens with the materials over in China. So you have this problem of what am I actually doing here on the R&D side in this country? And especially as time goes by, less and less of the current product development is tied to the patent. So it is a problem, and you have to do it early in the process because otherwise you get too attenuated from what your actual R&D was for the DI case to work.
Right.
So yeah, I mean, Ridge was in a lucky spot that they had the wherewithal to do the ITC case at a time when they were still doing R&D, where the patents were valid and enforceable, and it all lined up.
So is it a unicorn or not quite that rare?
I don't think it is. I mean, I don't know if people probably saw, but Yeti filed a case 2 weeks ago and asserted like 35 of their patents against one of their competitors. So it is not a complete unicorn, but that is a model that a lot of these kind of consumer good products are using. I think we have a distinct benefit of not ever having to deal with 101 problems. That's a huge, huge benefit because that takes some of the uncertainty on appeal out of the equation. But I think, kind of those consumer products companies are realizing that the design patents or utility patents that are essentially words around a design patent are very valuable.
Would you say the lesson here is if you're an entrepreneur, you're starting a new company, you've got to expect to win on brand, right? You can't think that I've got these patents and so I'm going to win.
Right.
You've got to win on brand, and you've got to succeed there and build a portfolio in parallel that then is useful when
people are copying.
Yeah. And you have because you've succeeded on that level, you now have the resources to do what a company needs to do. But you can't think, well, I'm going to put my life savings into this company because I have a patent, right? And so maybe the best message we could scream to the world to just spare so many inventors from so much torture and heartache is to not think that it makes good sense to put your life savings into a business.
Right, you need to build a company, and having a patent portfolio is not a panacea, right? I mean, it's just not. I mean, if you're one of the top 100 filers, and you can afford to be a top 100 filer, you've got some serious assets and capital and business, and maybe it works for them, right? Because they're trading patents here, the 50th largest filer and the 75th largest filer. Well, you've got assets that I need, I've got assets that you need. There's going to be a cross-license deal, and so they're flipping them like we did when we were kids with baseball cards, trading them like that. But if you're not that big and you don't have that kind of money to invest in this, then you need to build from the ground up and think about domestic industry and think about selling something in the U.S. and build your brand, and then the patents that you get, design should be a big part of that. I think a much bigger part than people do. Then you build the portfolio to support what you're doing.
Yeah, and the issue with the ITC is you can get funding to do ITC cases despite the fact that the only remedy they give you is basically an injunction. But to do that, you have to be able to show to the funder, I'm going to be able to leverage this exclusion order to get a settlement from the company of this amount of money to get out from under the exclusion order. The problem with a situation like what Ben is facing is there is nobody to leverage that exclusion order for, so that ITC case is essentially unfundable.
Right.
So what you're talking about is exactly right, because if you're in a case like what you're facing, you have to be able to fund the ITC case by yourself, because no funder will come in there and do it for you because you can't leverage it for money.
Right, because you have mostly small infringers who are just going to pop up under a different
But more
name.
than that, we won't take a monetary settlement. We don't want that. We're not going to do a settlement deal that a funder likes.
See, and then, okay, so in that scenario, I mean, you would seem to have all the equities on your side and be able to get an injunction because money is not a replacement for you. We want the market. We have the capacity. We want the market. We're selling in the market. And that's what you, I think, as an inventor, need to do is build that. And we talked a little bit about that yesterday about the lost profits case. Now, getting lost profits is really, really tough. But if you are, Michael, trying to start the company from some innovative technology, and they would listen to us and take our advice, you want to build so that you have an opportunity to try and build that way, right?
Yeah, it's so difficult though once you have multi-supplier markets, and how do you even go there? I think I agree with you. You want to build a business, and you got to think about this as I'm going to build a business. I'm going to bring in funding. I'm going to hire a team. I'm going to scale. It's going to be such there's tragic almost if you think that having some patents is going to be what's going to get you there.
Right.
Yeti, I apologize, but Yeti is Yeti, right? Not because they have 60 patents they can assert, because of the brand.
Right.
Yeti, I mean, that's just,
Right.
yeah.
That's why they got the
Right.
GEO. I
Yeah,
mean,
I apologize.
that's why they got the GEO.
Yeah.
And Ben, it sounds like you're able to do it fairly efficiently by doing it mostly in-house, other than in situations where you need local counsel.
Yeah, I
That
mean,
probably helps
I think
too.
outside lawyers get kind of caught up in this idea that a protective order is going to prohibit you from litigating as an in-house lawyer, and it really, especially with this product where there's no technology that's confidential, protective orders don't affect anything. There's no prosecution bars. There's nothing that I get from competitors where they're like, we don't want you to keep prosecuting the patents at the same time. So it really isn't that. If the company is comfortable with whatever risk there is to having the in-house lawyers do the litigation, not have the malpractice insurance of an outside firm, it's totally doable.
We talked a little bit about this with Brian yesterday, not about this specifically, but he was talking about how in his industry, the a niche aviation market, for shorthand here, there's a lot of people that they're patenting this component, that component, this safety feature. That's another great strategy, right? I mean, because then you get to the point where at least some of what you're doing, that presumably if you're going to get knocked off or somebody's going to come into the market, they're going to want to have this feature in their product. And if you could put your hand on it, you would suspect, not certain, but if you can hold it, that the Federal Circuit's not going to have a one-on-one problem.
Right.
They did with the drive shaft, obviously, which is something, if I threw at the judge's head would leave a mark. And I don't understand how that's abstract, but or a natural law or whatever dumbass thing that they said it was. But I mean, if I throw something at you and it's going to leave a mark on your forehead, it can't fail 101.
That one-on-one, the lack of one-on-one risk is so deluxe, because I was doing, tech litigation mostly at the firm, and it is so nice to never have to deal with one-on-one anymore.
Yeah.
It's such a benefit I didn't even know existed, and Ridge doesn't, they make a metal wallet, so they've never thought about that issue, but it's such a deluxe thing to not have to deal with.
So, and this also distinguishes a lot of times, Michael, the small inventors who are starting out, thinking about trying to patent the big grandiose, so I invented this huge thing. Good for you, great. But what's going to win the day is if you patent a whole bunch of little tiny things. If what you do is like the car industry, they make their cars so that the headlight, the only weird shaped headlight that can go in there is the one that they have a design patent on.
Yeah, but that's a luxury of team and resources, right?
Right.
So if you're a new company and you believe in your technology, you believe in your,
Right.
whatever it is, your number one goal has to be, I'm going to protect my product with
Right.
my, excuse me, with my limited financial dollars. The first thing I do is protect my product.
Right.
If I'm able to scale my team and have more money, then I can think strategy, and I'm going to do this and this and this.
Yes and no. I mean, certainly, yeah, you go to the scale. Maybe the story ought to be to patent attorneys who, don't miss the forest for the trees. Don't just try and patent the big overriding system. Yeah, I'm not saying don't describe it, but let's make sure we have individual trees that we can touch and put our hands on, and we're patenting the pieces. Because ideally, you're going to have an omnibus, like you said you do, right? You're going to have an omnibus filing that gives you a whole lot of ability to grow in whatever direction you want. That's best practices, and it seems to me that the only way to operate anymore as a patent owner is you have to be engaged in best practices or save your money.
What you're saying is you need patent strategy, which is different
Yes.
than patent prosecution, and it's different from patent litigation. It's a different animal.
Totally different
Yes.
animal, and a lot of patent attorneys don't do it particularly well because the client comes and says, "Oh, I want to patent this." Okay, and they'll get you a patent on exactly that. They won't ask you, "Oh, well, could it be smaller? Could it be bigger? Could be, does it have a gyroscope? Or, what? All kinds of things."
You always have to ask why. Well, like, why do you want that patent? What are
Right.
you trying to accomplish with that patent?
Right.
Well,
Right.
But
That's true, but I will tell you that in every invalidity challenge we've ever seen, the first piece of prior art is our Kickstarter webpage, which I can't get around. Seriously, it predates the patents, and that is a problem that
It is a
existed
problem.
in 2013 when that website was published.
So, and I hate, you gotta file first. And people that put up their Kickstarter, and not only for that reason, but there was, the As Seen on TV people, this came out in the Josh Malone's Bunch of Balloons litigation, I think it was. It came out in somehow, is they had a standing policy, if anybody raised $100,000 or more on Kickstarter, they copied it and tried to beat them to the market. you know, and then they would deal with any patent issues later, you know, if they came up.
It's still happening, like
Totally.
a lot. Yeah.
Totally.
Yeah.
I mean, so, yeah, okay. Well, I'm looking at the clock, and we've gone a full hour here. This is a fascinating conversation. I think there's some hope for some people, a lot more than a lot of people may have thought. The question is, not as many people as we would like probably fit into that basket, but if you do, it's an interesting strategy. There are other strategies, and I think the big takeaway for me, and I'll ask each of you for your takeaway, and I'm going to steal your thought, Michael, because I think you very succinctly put it. What you need is a patent strategy, which is different than patent litigation and different than patent prosecution. The strategy, I think, needs to define the prosecution strategy, and it needs to inform your litigation strategy. But it has to exist. That's my takeaway, and I thought you put it very well. So I'll let you go first. Since I stole yours, you can go.
Last thought, I guess, is a little tangential, but I think we talked about the Amazon court today, kind of like a public service announcement. It seems like a great idea. I can tell you it's maybe a very risky strategy for a lot of smaller companies. Last week, there was a decision from the Federal Circuit, that basically affirmed the idea that a big company that's brought into the Amazon court will have can file a DJ in their forum, right? And so we see this a lot right now. Smaller companies, they go to Amazon, they're not aware of the DJ risk of doing it. And what they're getting now is the big company who is on Amazon has, they're filed and not served, but they're basically like, hey, back off, right? Like, we're going to do this, we're going to take this market, or you're not going to be able to afford this, what we're about to do to you, if you continue. And so I guess last thought would just be, as we think about the Amazon court, it also has its, significant, I think, risks if you're a smaller company.
Yeah, it does. And I think it's a great idea. I think it needs some work. But, all right, thanks. Ben Weed.
Yeah, so I guess my biggest takeaway is, our CEO just turned 30, and so it's a very young company, and I think in all of these aspects, defining what a win is, talking to your client about who to assert against first, funding a litigation, I think the most important thing is that the non-patent decision makers have to understand all of these intricacies, not maybe on the merits, but they have to understand that a judgment for $700 million is not that valuable because it's not going to stick. They have to understand that there's going to be a Rule 12 motion on 101 that even if they win it now, might be fodder for appeal later. Our client has to understand, the CEO has to understand that Amazon isn't going to get involved all the time. And even though we're a big seller on Amazon, they have bigger fish to fry than helping us with our knockoff problem. I think the biggest thing as a patent owner is that we all as lawyers who live the life, understand a lot of stuff kind of innately. There are a lot of people who don't understand all those intricacies, and if they do, or at least better at it, it'll help the whole thing be more successful.
Great, thanks. Ben Herbert.
I would say, I think a lot of us that are in the patent litigation community sort of see a sense of doom and gloom out there. And I think the reality is you can still get good wins. It's just you have to think a lot harder about how you get there based on sort of all the headwinds that you face as someone trying to assert a patent. But if you go into it and are thoughtful, you can still accomplish wins for clients.
Great, thanks, Ben. And Amanda, you have the final word.
Sure, and what I'm going to say has to play off of what both Bens have to say. Generally we deal with clients that have a fairly sizable patent portfolio. It really only works if you're talking about at least 30 plus patents, usually in the thousands. But part of what I want the takeaway to be is if you're working with clients like this, to ask them what their long-term goal is. Often they come with an immediate action that they want to take, but what's more important is what's the long-term goal for that portfolio? Where do you want to see that portfolio be in 5-10 years, and let whatever that immediate next step be informed by that long-term goal. So you can set up that plan to get to that point based on that first step without just taking that action that the client wants. It sets up for a more successful campaign.
Yeah. Okay. Great. All right. Thank you, everybody, for being here for this panel. I appreciate it, and we're going to take a break. Let's take 25 minutes and